Welcome. As you may know, I am Juliet Rizzo, your moderator for today's event. This segment of the video is devoted to answering some of the questions that the Office of Special Education Programs, or OSEP, has received about regulations implementing the Individuals with Disabilities Education Act of 2004, or IDEA 2004. To answer these questions, I have with me today Alexa Posney, whom you've met in earlier segments and know as the Director of OSEP, Lou Danielson, the Director of OSEP's Research to Practice Division, or RTP, and Ruth Ryder, Director of OSEP's Monitoring and State Improvement Planning Division, or MSIP. Welcome, panelists.
Hello, Juliet.
Hi, Juliet.
I know OSEP has received a lot of questions about the regulations. How did you select the questions that would be addressed during this segment of the video?
I can answer that, Juliet. We collected questions that our staff members and our policy unit received from constituents across the country. We tried to select questions that met two criteria. One, they are broad questions that would be of general interest, and two, they address major changes in this reauthorization.
That seems like a good approach since this video will reach a broad audience. So let's begin with the first question. I've heard that there are changes in the Individualized Education Program, or IEP, that will affect parents and the decisions they make. What are those changes?
These are significant changes, and it's very important for parents to understand them. First, let's talk about a provision that allows members of the IEP team not to attend an IEP meeting if the parents and the local education agency, or LEA, agree in writing.
But that's only if the team member section of the IEP is not being changed or discussed at the IEP meeting.
True, if the member's area will be discussed at the meeting, they may still be excused, but only if the parent and agency agree. The parent consents in writing, and the excused member submits before the meeting written input into the development of the IEP to both the parents and the IEP team.
And I want to emphasize again that the team member can only be allowed not to attend if the parent and the LEA agree in writing, and in the case of a member whose area is being addressed at the meeting, when the parent provides written informed consent.
Can a state determine that IEP members cannot be excused from IEP team meetings?
A state must allow a parent and an LEA to agree to excuse a member of the IEP team. A state also may not limit or otherwise determine when an IEP team member can be excused from attending a meeting.
And the state cannot prohibit the excusal of an IEP team member when the LEA and parent agree to the excusal. Whether a state must have policies and procedures to excuse IEP team members from attending an IEP team meeting will depend on whether they are required by a state to implement this requirement. However, every state must allow a parent and an LEA to agree to an excusal.
It really sounds like Congress wanted to be sure there is reasonable flexibility in IEP team attendance. Are there other IEP changes?
Yes, there's also a provision for amending an IEP without having a meeting.
Does that mean that they don't have to hold the annual IEP meeting?
No, the meeting to review and, if necessary, revise the IEP must still be held at least once a year. But if there are changes that need to be made to the IEP after the annual IEP meeting, a written document describing those changes can be developed without another IEP team meeting, provided the parent and the LEA agree that another meeting is not needed.
So what happens to the changes?
The IEP developed at the annual meeting and any amendments developed later become part of the IEP. The parent can request a revised copy of the IEP with the amendments incorporated.
What about the other IEP team members who don't participate in deciding on these changes?
The LEA has to ensure that all members of the IEP team are informed about any changes that the LEA and the parent make to the IEP.
Changing gears just a little, since I think parents will be really interested in this topic too, how are IEPs and IEP meetings different under IDEA 2004?
Consistent with the statute, the regulations do not include a requirement for secondary transition planning and services beginning at age 14. However, states are permitted to begin to plan and provide transition services earlier than the required age of 16. Transition planning and services must begin earlier if the IEP team determines that it is appropriate.
So LEAs don't have to think about secondary transition for students with disabilities until they are 16 years old.
Not exactly. The IEP must include transition content no later than the first IEP in effect when the student turns 16. If the IEP team thinks it is appropriate, that content can be included at an even younger age. Once transition planning and services begin, they must be updated annually.
What content is required?
There's actually a lot of content packed into just a couple of paragraphs in the regulations. Transition content includes appropriate measurable post-secondary goals based upon age-appropriate transition assessments related to training, education, employment, and where appropriate independent living skills. And it has to include the transition services, including courses of study, needed to assist the student in reaching those goals.
That is a lot of content, but I know because of our conversation about what parents need to know that there are other IEP changes as well. We talked earlier about excusing some IEP team members and amendments to the IEP. Is there anything more than what we mentioned earlier?
We actually covered the new issues around excusing members of the IEP team when the parents and LEA agree. And we talked pretty thoroughly about amending the IEP after the annual IEP team meeting. But I'd also like to mention a couple of other changes to the content of the IEP, other than the secondary transition requirements. It's important to know that the present levels now refer specifically to both academic achievement and functional performance. Also, there's been a change around the short-term objectives or benchmarks. Now, these are only required for children who will be assessed against alternate achievement standards.
That certainly provides flexibility for both schools and parents. Are there other changes that we want to tell parents about today?
I think one of the major provisions further aligns IDEA with the No Child Left Behind Act, or NCLB. The final regulations include provisions for children with disabilities to be taught by highly qualified special education teachers.
What can parents do if they find out that their child is not being taught by a highly qualified special education teacher? Can they request a due process hearing?
No, they can't request a due process hearing. We always encourage parents to try to resolve issues at the building level. It would make sense for them to talk to their child's principal first, before doing anything else, to find out what the school is doing to ensure that the teacher gets the training that he or she needs to meet the highly qualified standards. And if they are not satisfied with the steps the LEA is taking, they could file a complaint with the State Education Agency, or SEA. The SEA must make sure that the LEA is taking measurable steps to recruit, train, hire, and retain highly qualified special education teachers.
Does the requirement for highly qualified teachers apply to public charter schools too?
It does. That raises a larger issue regarding charter schools as well. The final Part B regulations still require that a school district serves or provides funding for children attending public charter schools of the district in the same manner as children it serves or provides funding for children attending any of its other public schools. The final regulations for IDEA 2004 now specifically also say that these requirements include providing services on-site at the charter school if the school district provides those services on-site at its other public schools. This is something parents of those children need to know and understand.
I have heard questions asked about parental consent when special education services are first provided. What's behind this issue and what do the regulations say about it?
When an LEA requests parental consent for an initial evaluation and the parent does not provide consent, the LEA can seek consent through due process hearing procedures. In the past, some states used those same procedures when a parent refused consent for initial provision of special education and related services. We believed, though, that the changes to the IDEA in 1997 meant that those same procedures did not apply to situations when parents refused to provide consent for the initial provision of services. Now, however, IDEA 2004 and the final regulations clearly state that if a parent does not want the district to provide special education and related services, those services cannot be provided. In such a case, schools cannot be held accountable at a later time for failure to provide a free appropriate public education, or FAPE.
That's pretty clear, and it seems to be a balanced approach to a difficult situation. You mentioned due process hearings. Has anything changed for parents in the area of due process?
This is a really big subject.
Parents now must provide notice to the LEA that includes certain information when requesting a due process hearing. To help parents do this, states must provide a model form to use when parents request a due process hearing. The form must identify the specific content required in the notice. That should make it easier for parents to be sure they include all the required information. No due process hearing can be held until a due process request is submitted that meets the requirements. Alexa, didn't something change around mediation as well?
Yes, and specifically in relation to due process hearings. First, though, I'd like to add to what you said, Lou, about due process hearings. It's important for parents to know that they cannot amend their request for a due process hearing by adding or changing the issues unless the other party agrees or a hearing officer grants permission at least 5 days before the hearing. Of course, if parents discover that they have a new issue in dispute with the school district, they can file a separate due process hearing request. Now, to mediation. Under the previous regulations, states were only required to offer mediation when a due process hearing was requested, although many offered mediation at other times as well. The regulations for IDEA 2004 require that mediation be available whenever there is a dispute, whether or not there has been a due process hearing request. This is to encourage that disputes be resolved before the need for a due process hearing arises. There continues to be a requirement that when an agreement is reached as part of mediation, it is written up in a legally binding agreement. However, now either party to an agreement has the right to change their mind and void that agreement within 3 business days after it is signed.
Congress added another requirement that is also intended to encourage dispute resolution before getting to a due process hearing: resolution meetings.
I haven't heard that term before. It must be something brand new. Tell us about it.
It is brand new and more than a little complicated. But before we get into more of the details, I would like to set a little context. The House of Representatives Committee on Education and the Workforce published a guide to frequently asked questions. It explained that the resolution session provision was added to provide an opportunity for parents and LEAs to resolve any issues so that a due process hearing could be avoided. This, of course, would benefit the child.
Exactly right, Alexa. We believe Congress, in IDEA 2004, made several attempts to offer and encourage opportunities to resolve disputes without the need for due process hearings. The resolution meeting is certainly one of those opportunities.
So what are the details?
Within 15 days after a due process hearing request is filed and before the hearing, the LEA must convene a resolution meeting with the parents and the relevant members of the IEP team who have specific knowledge of the facts laid out in the complaint. The parent and LEA determine who are the relevant IEP members. The meeting must include a representative of the LEA who can make decisions for the agency. The meeting may not include an attorney for the LEA unless the parent is also accompanied by an attorney. The meeting provides an opportunity for the parent to discuss the issues and an opportunity for the LEA to resolve the issues. An LEA has up to 30 days from the date they receive the parent's due process request to attempt to resolve the issues. Due process timelines can't begin until the end of this 30-day resolution period unless the parent and the LEA agree to waive the process or agree to mediation instead.
Parents need to understand that they need to participate in the resolution meeting because their failure to participate will delay the timelines for the resolution process and for the due process hearing until the meeting is held.
That's right, Lou. Ultimately, if an LEA is unable to get a parent to participate in a resolution meeting after it has made reasonable efforts to get the parents to meet, it can, at the end of the 30-day resolution period, ask a hearing officer to dismiss the parent's due process request.
On the other hand, if an LEA fails to hold a resolution meeting within 15 days of receiving the parent's due process complaint, or fails to participate in the meeting, the parent can ask a hearing officer to begin the due process hearing timeline.
Phew, this is really complicated. I'm beginning to see that there is a lot of new information for parents, LEAs, and states to learn. Have we covered it all?
No, not quite. If the parties reach agreement through this process, they must execute a legally binding agreement that is signed by the parents and a representative of the LEA with the authority to legally bind the LEA. This agreement is enforceable in any state court with the authority to hear such cases or a district court of the United States. The regulations also permit a state to use other mechanisms to enforce a resolution or mediation agreement, provided their use is not mandatory and does not delay or deny a party the right to seek enforcement of the written agreement in court.
What happens if the issues are not resolved?
At the end of the resolution period, the parties would proceed to a due process hearing. The parties can also agree not to conduct the resolution meeting, as we mentioned earlier, if both agree in writing to waive it or if they decide to use mediation.
Can you explain again how the timelines work? I know we have mentioned the timelines, but I think it would help to walk through them again.
Of course. For most due process hearing requests, the timeline works like this. Within 15 days of receiving the request for a due process hearing, the LEA must convene a resolution meeting. If both parties agree in writing to waive the resolution meeting, the due process hearing timeline would begin when the waiver is signed. Alternatively, the parties can agree to mediate the dispute instead of going through the resolution process. If the issues are resolved at the resolution meeting, the legally binding agreement is executed. If it is not voided by either party within 3 days, the situation is resolved and there is no due process hearing. If the meeting is held, the LEA has 30 days after the due process request was received to try to resolve the dispute. At the end of this 30-day resolution period, if the parties do not reach agreement, the due process hearing timeline begins. The actual due process hearing timeline did not change from the previous regulations. A decision must be reached and mailed to both parties within 45 days of the beginning of the timeline, unless it's extended at the request of either party. However, the point at which the 45-day timeline begins did change, as we've described.
So once we grasp the impact of resolution meetings on the timelines, much of the due process procedural provisions are the same.
A lot of it will be familiar. There are a couple of fairly significant changes I think we should mention. There are some provisions about filing a due process hearing request that are different. As we mentioned before, there is now a requirement for filing a due process hearing request that contains specific content. There also are new procedures and timelines if the receiving party thinks the due process request does not include the required information. As we mentioned earlier, there are some limitations on changing the request once it's been filed. It can only be amended if the other party consents in writing to the amendment and is given a chance to resolve the issues through a resolution meeting. Or it can be amended if the hearing officer grants permission at least 5 days before the hearing begins. The regulations also are now specific that the due process hearing complaint has to be sent to the other party and a copy sent to the SEA.
That reminds me that there are also some changes regarding hearing officers. As in the previous regulations, a hearing officer must not be an employee of the SEA or LEA that is involved in the education or care of the child, and must not have a personal or professional interest that conflicts with the objectivity in the hearing. The IDEA 2004 regulations add that a hearing officer must know and understand the provisions of IDEA, relevant federal and state regulations, and legal interpretations of IDEA by federal and state courts. The hearing officer must know how to conduct hearings in accordance with appropriate standard legal practices. The hearing officer also must be able to render and write decisions in accordance with appropriate standard legal practice.
There are also some new rules about how the hearing officer makes decisions. A determination of whether a child received a free public education, or FAPE, must be based on substantive grounds. If the issue is a procedural violation, the hearing officer can only find that a child did not receive FAPE if the violation impeded the child's right to FAPE, significantly impeded the parent's opportunity to participate in the decision-making process regarding FAPE, or deprived educational benefit to the child.
There's a lot of new information here. What else do parents need to know?
There are several other things I'd like to mention. The final regulations establish a timeline of 60 days from the time the LEA receives the parent's consent to complete an initial evaluation. However, if the state established a different timeline, then that timeline applies. The regulations also make clear that reevaluations do not have to be done more than once a year, unless the parent and the LEA agree otherwise.
The final regulations also make clear that parents may not request an independent educational evaluation except in response to an evaluation obtained by the agency with which they disagree.
There is a provision in IDEA 2004 and the implementing regulations for awarding attorney's fees to an LEA or SEA under certain circumstances. Ruth, can you explain the conditions for awarding attorney's fees to an LEA or SEA?
Certainly, there are two new circumstances under which fees can be awarded against an attorney of a parent, or in some cases, a parent. The first circumstance allows the award of attorney's fees to an SEA or LEA if the parent's attorney files a complaint or subsequent cause of action that is frivolous, unreasonable, or without foundation. This also applies if the attorney continued to litigate after the litigation clearly became frivolous, unreasonable, or without foundation. The second circumstance is again when attorney's fees can be awarded to a prevailing SEA or LEA against the parent's attorney or against the parent if the parent's request for a due process hearing or subsequent cause of action was presented for any improper purpose, such as to harass, to cause unnecessary delay, or to needlessly increase the cost of litigation.
That's a lot for parents to know.
Yes, and states, LEAs, and attorneys as well. We hope that some of the technical assistance resources that we highlighted in our previous video segment will help everyone understand these complicated provisions better. Also, the IDEA 2004 curriculum being developed will include information specifically targeted to parents, advocates, and attorneys.
So help is on the way.
That's the plan.
I've heard a lot about something called response to intervention. What is this all about?
The regulations require states to adopt criteria for determining whether a child has a specific learning disability. As part of the evaluation procedures, the criteria must permit a process that determines if the child responds to scientific, research-based intervention. Because OSEP has funded research for some time around response intervention, or RTI, we tend to refer to this requirement as the RTI provision.
So OSEP has created a model for states to use to meet this requirement.
Not quite. The RTI model that has grown out of OSEP-funded research is one of several models that the state can adopt. Our focus is to use those models in conjunction with providing early intervening services and progress monitoring. This would address the needs of children before they are identified as needing special education. It would also begin to build a body of knowledge about each child to help teachers develop methods to ensure school success for that child. The statute and final regulations also allow LEAs to use up to 15% of their IDEA funds to develop and implement coordinated early intervening services for children kindergarten through grade 12. There is a particular emphasis on children in kindergarten through grade 3 who need additional academic and behavioral support to succeed in a general education environment. These children have not been identified as needing special education or related services. Activities can include professional development for teachers and other school staff to deliver scientifically based academic and behavioral interventions. These also might include literacy instruction or instruction on the use of adaptive and instructional software. LEAs also can provide education and behavioral evaluations, services, and supports. For children who are not succeeding in the general education environment, implementing early intervening services and using a systematic progress monitoring structure is an opportunity for LEAs to measure a child's response to scientifically based interventions.
So OSEP is encouraging states to assist LEAs in creating a systematic method for identifying children's response to interventions before recommending special education evaluation.
That's right. We're very excited about the results from our research. We're convinced that these models offer LEAs support they need to implement requirements in a cohesive way.
That clarifies some of these new provisions. We'll have to watch for more information on this as the technical assistance resources become available.
There's actually a lot of information already available through the projects in our Special Education Technical Assistance and Dissemination Network.
Alexa pointed out to us that the IDEA website will have a link to those projects, so everyone will be able to find out what's already available.
That's a great place to start, and more information will be developed as we move forward under the final regulations.
Thanks, Lou. I'm going to shift gears again and take us to another question received by OSEP on a somewhat different topic. What is the impact of the change in responsibility for children with disabilities who are placed in private schools by their parents?
This is a significant shift from the old law to IDEA 2004. Previously, when parents placed their child in a private school, the LEA where the parents lived was responsible for identifying, locating, and evaluating children with disabilities. The LEA also determined the proportionate share of funds to be spent for those children and how to provide equitable services to them. Under the final IDEA 2004 regulations, that responsibility is now shifted from the LEA where the parents live to the LEA where the private school is located. An LEA that has a number of private schools within its jurisdiction may have to consider the needs of more private school children than in the past. However, private schools now only have to deal with a single LEA.
I know that some children with disabilities are enrolled by their parents in private schools in a state other than the one in which they live. What is the responsible LEA in these situations?
There is no distinction in the law for children attending a private school in one state but who live in another state, and those who attend a private school in one LEA but who live in another LEA in the same state. It is still the LEA in which the private school is located that has responsibility for implementing the regulatory requirements regarding children with disabilities placed by their parents in private schools.
One last question around these private school issues, and then we'll move on to another topic. Who is responsible for ensuring that the requirements are implemented for children with disabilities who are preschoolers and placed in private schools by their parents?
Under IDEA 2004, children with disabilities aged 3 through 5 who are placed by their parents in private schools are only entitled to equitable services if they attend a private school that fits the state's definition of elementary school.
So, if a state defines an elementary school as beginning with kindergarten, preschoolers with disabilities whose parents place them in private preschools may not receive equitable services.
That's correct, Juliet. It really depends on the state's definition.
Thanks, Alexa. That's helpful. Let's move on now to a question regarding the highly qualified standards that we touched on earlier. If a special educator must be highly qualified in both special education and core subjects that he or she teaches, why don't regular educators who teach special education students in their classrooms have to be highly qualified in special education?
I'll take that question. We know that special educators are the experts in modifying instruction for the particular needs of children with disabilities. They also are often the people who provide direct instruction in core academic subjects to children with disabilities. So under both IDEA 2004 and NCLB, they need to be highly qualified in both areas. Regular educators are generally not delivering specialized instruction, at least not without assistance from a special educator. Yet they are responsible for instruction in core academic subjects. A regular educator would rely on the special educator's knowledge to help them meet the needs of particular children in their classroom.
Thanks, Lou. Shifting gears again, here's an interesting question on an IDEA topic that we hear a lot about. What are the major changes in the discipline procedures?
There have been several changes in this area. The first one that comes to my mind is the addition of serious bodily injury to the list of behaviors that can result in immediate removal to an interim alternative educational setting.
How do you define serious bodily injury, and what are the others in that list?
The term serious bodily injury is defined using a cross-reference to a definition in federal criminal law and means bodily injury that involves either a substantial risk of death, extreme physical pain, protracted and obvious disfigurement, or protracted loss or impairment of the function of a bodily member, organ, or mental faculty. The other two concern weapons and illegal drugs or controlled substances and were part of the previous regulations.
That definition certainly brings home the seriousness of this topic. Are there other changes?
I think it's interesting and helpful that there is some clarification of the use of functional behavioral assessments. You may remember that the previous regulations required that a functional behavior assessment be provided after a student had been removed for more than 10 days in a school year. The final IDEA 2004 regulations provide that a functional behavioral assessment be provided, when appropriate, for behavior determined not to be a manifestation of the child's disability, and that results in a disciplinary change of placement exceeding 10 consecutive school days, or for a removal of up to 45 days for violations related to weapons, illegal drugs, or inflicting serious bodily injury. The final regulations require the IEP team to conduct a functional behavioral assessment and implement a behavior intervention plan for a child whose behavior is determined to be a manifestation of the child's disability, or if the child already has a behavior intervention plan, to review and modify it if necessary to address the behavior.
Speaking of deciding whether the behavior is related to the child's disability, the criteria for making that determination have changed in the final regulations. The previous regulations required considering all relevant information. The IEP team was required to determine several things in relationship to the behavior for which the child is being disciplined.
Let's see if I can remember all of them. The IEP team had to determine whether or not, in relationship to the subject behavior, the child's IEP and placement were appropriate. Special education services, supplementary aids and services, and behavior intervention strategies were provided consistent with the child's IEP and placement. Whether or not the child's disability impaired his or her ability to understand the impact and consequences of the behavior, and whether or not the disability impaired his or her ability to control the behavior.
Well done! The final IDEA 2004 regulations require the IEP team to consider all relevant information in the student's file, including the IEP, teacher observations, and relevant information provided by the parents, and determine if the conduct in question was caused by or had a direct and substantial relationship to the child's disability, or if the conduct in question was the direct result of the LEA's failure to implement the IEP.
That is quite different in terms of what the IEP team determines.
It is. And there's a similar major change when an LEA is determining whether a series of removals constitute a pattern of removal. In the previous regulations, a series of removals constituted a pattern if the child was removed for more than 10 school days in a school year. Other factors to be considered included the length of each removal, the total amount of time the child is removed, and how close the removals were to one another. The IDEA 2004 regulations add one significant consideration. The public agency now also must consider whether the child's current behavior is substantially similar to the child's behavior in previous incidents that resulted in the series of removals. That wasn't part of the previous regulations.
Isn't there also a change around the expedited due process hearing when a parent appeals a manifestation determination?
There is a change. A parent can request a hearing to appeal not only a manifestation determination, but also placement decisions related to disciplinary removals, including removals to an interim alternative education setting. An LEA can request an expedited hearing if it believes that the current placement of a child is substantially likely to result in injury to the child or others. The final IDEA 2004 regulations set out a different timeline from the previous regulations and require that the expedited due process hearing occur within 20 school days of the date the request is filed. A determination must be made by the hearing officer within 10 school days after the hearing.
And the expedited due process hearing affects the timing for the resolution meeting, too. If the problem has not been resolved, a resolution meeting must be held within 7 days of receiving the request, and the hearing must proceed, unless the matter has been resolved to the satisfaction of both parties within 15 days of receiving the request.
That's right, Ruth. And the regulations also allow a state to establish different procedural rules for expedited due process hearings than the state has for other due process hearings, as long as the state ensures that both the expedited timelines and all the other IDEA requirements related to due process hearings are followed.
These seem to be complex technical changes.
I agree. But we wanted to answer these questions because the changes, while complex, are important in the way states and LEAs address disciplinary matters. And the information is important for parents to know. We'll have a video clip on our website that will explain these details in more depth.
Interesting. It sounds like many of the changes from the previous regulations are substantive and not just technical.
We think so. We believe that Congress made many changes to improve accountability, support an effective provision of services to children with disabilities, and ensure that the rights of parents and children with and without disabilities are protected. Again, there is a substantive alignment between NCLB and IDEA in the new legislation that carries over into the implementing regulations. We really believe these regulations will improve results and outcomes for infants, toddlers, children, and youth with disabilities and their families.
Thank you, Alexa, and thank you, Ruth and Lou, for being here today and answering some of the questions that have been raised about the IDEA 2004 Final Part B regulations. Throughout these video segments, we have seen how IDEA 2004 and the Part B regulations support the Secretary's mission to ensure that no child is left behind and that children with disabilities receive the same high-quality education as children without disabilities. We've heard from the Secretary, from Assistant Secretary John Hager, and from Alexa Posney, Ruth Ryder, and Lou Danielson. They addressed the key changes in these regulations and the technical assistance resources available to implement these changes. In the coming weeks and months, you will hear about more of the activities and resources that will provide support. We hope the information provided in this video is helpful to you. Remember to look for the new information at idea.ed.gov, the Department's official website for IDEA 2004 resources. If you have questions, please submit them through the Q&A corner on that website. Thank you for being with us today, and thank you for your attention.